I'll say that again. A lot of people are surprised. Certainly my teenage and college-age sons are surprised when I tell them the First Amendment doesn't apply to them when they mimic back that, well, I have a free speech right, Dad, to say that. No, you don't. I'm not the government, and I'm not trying to impinge that. And whatever happens outside those doors, you got some free speech rights. But in here, you absolutely don't. And their mom loves to drive that one home. The instructive cases, that's where I said I'll go through some case law, and I'll try to go through quickly because it's really designed more for lawyers. But I left it in there because I think if you all want to read it in detail to learn how the results happened in those cases, I think you'll find it interesting, and you might have a case that's similar or a set of facts similar in your agency. I'm going to spend a lot of time talking about social media issues because that is what I get phone calls on every day. And I'm sure you all have issues. Your HR people have issues dealing with that all the time. I'm going to remind you about whistleblower and retaliation statutes so you can remind your managers, your supervisors, your HR people about the importance of that, because that's the hot thing now, is to claim I'm a whistleblower or I've been retaliated against. And then I'm going to talk about PARA, the Public Employee Relations Act, and a little bit about the National Labor Relations Act, which doesn't apply to you all because you're exempted. PARA applies to you. It does not apply to state and local governments. But why do I want to talk about it? Because there's a whole lot more cases under that statute. It's a similar statute to our statute, so it gives you an idea where you can have a landmine or two. And then I'll save time for questions and answers, but again, I would like y'all to ask me questions as we go, so we make this more interactive rather than me just lecturing. So this is the bird part of it. Anybody remember this? That's Julie Briskman telling President Trump as he drives by what she thinks of him, and she's saying, read between the lines when he goes by. This made national news because a lot of people felt that way, and she also personally put it on her Facebook after somebody took a picture of her, and then it got to her, she put it up on Facebook, which then led to an employment problem for her. Why? Because ICMA, her employer, is a government contractor. And government contractors are worried about what somebody sitting in the Oval Office thinks of them, right? So that led to Ms. Briskman being fired for telling the President of the United States her opinion of him, which all of us would agree we have the right to tell the President of the United States what our opinion is of him. But we have to do it in a way that does not harm the workplace. And that's the problem with social media now. If this had happened even 20 years ago, she'd probably still be employed. Nobody would have it on camera. Nobody would know about it. She might tell her friends, but it wouldn't be so disruptive. So this led to her filing a lawsuit in Fairfax County Circuit Court claiming that she was unlawfully fired. And the court dismissed that lawsuit because the employer had the right not to have a disrupted workplace and have a disrupted relationship with the government with whom it had a contract. She didn't have a First Amendment right to do this because it's a private employer. Even though interacting with the government, it's a private employer. And like I said, my law firm, I can stop my associates from saying things that might be offensive to my clients. And they can stop her from doing things that might be offensive to the current administration. So that's an instructive case. That covers the birds. The knees. Everybody remember this? Still a big social issue in this country about how African Americans are treated. And if you all recall, and those of you that are not football fans, you may have heard of this, but I'll just briefly cover it. This was a way that the players showed solidarity in support of racial issues in this country and having people become aware of them or pay attention to them. And it was a great way to get everybody's attention, right? What happened to the people, or the players at the Dallas Cowboys, Jerry Jones, the owner, he flip-flopped on this issue multiple times. At first, he was like, no, you can't take a knee. And when he did that, he said, if you do take a knee, you'll be benched. So the players, they have a union, right? Everybody knows that. Most of y'all should know that. So what happened is they complained to the union. So the union files a grievance saying that they're engaging in protected, concerted activity on behalf of the players in the football league, right? That's not really accurate what they were doing. What they were doing was, showing solidarity for African Americans in this country and highlighting the racial issues that we face in this country and the divide. And that's not an employment issue, right? When you have an employment issue, it has to be terms and conditions of your employment, like pay, hours, overtime, shifts, things like that. Now, it could be, of course, if you don't have a anti-harassment policy, then you can, employees can work together and get the employer to change that. But that's not what they were doing. So ultimately, their charge was dismissed because they weren't complaining about anything in the workplace. But I use this as an example, as they would have a free speech right, again, if they worked for the government or they did it outside their workplace, as long as it doesn't disrupt their workplace. Then the third one is tweets. And I think we're going to be getting, some more the next year or so because President Trump's running again. So we're going to get some crazy tweets. And the reason I brought this up is that President Trump tried to have it both ways with his tweets. He wanted to put out what he wanted, and then he wanted to block people responding to him. That led to a lawsuit. And this is an example when the First Amendment did apply. The Knight First Amendment Institute at Columbia University filed a lawsuit and said, President Trump, you can't block our comments back just because you don't like them. This is a public forum that you're using. So it's like you going out on the steps of the White House and saying the words that are in the tweet. And we have a right to stand there and respond back, but we're doing it ethereally through a tweet. We're responding back to you. And you can't stop that. And they were right. And Trump lost that case. He appealed it, but it was later dismissed as moot. Why? Because he didn't get reelected. So the case went away. So that is the initial backdrop. Then you look at, some of y'all may have seen scenes like this, and we all know or have heard multiple times about the January 6th riots and what happened there. And that has really upset a lot of people, polarized our country even more. So I'm going to talk about speech issues in that regard, how they permeate our news cycle, which means that your employees are constantly being inundated with this. If they pick up their phone and they have a news feed, they get something on there that is related to social issues in this country, I guarantee you. And then they might react, and they might say something in your workplace. And what can you do about that? Well, you can stop it if it disrupts your workplace. Even though they have a First Amendment right to share their opinion, it's not without limits. And we're going to discuss those limits today. So because of that social media constantly being in their pocket, they feel emboldened. It's amazing to me, having done this now for almost 35 years, and several of you are probably my age in the audience. Remember when we just stand on a break around the water cooler or by the coffee pot? That's how we communicated at work. Now people sit at their desk and communicate constantly, whether it's IMs or Facebook or whatever. They're doing it sometimes not work-related, right? At least my associates are doing things that aren't work-related constantly on their computers and on their phones, and it becomes disruptive. And so what do you all do as a public agency with the First Amendment? What would you do, for instance, if somebody walked into work like this? I would hope you would say, take all that stuff off. They would say, well, I have a First Amendment right to express myself this way. Not if it scares the other workers, right? Somebody might be intimidated by somebody showing up like that because they're trying to hide their identity. And it's been easier now because of COVID. And so you get a lot of the cases that you see, and some I'll talk about, involve masks in the workplace. And I'm going to ask you all some questions about that, what you would do. Some of them involve Black Lives Matter. There's multiple cases that involve that. And there are people that obviously support it, and there's people that don't support it. Either way, if it upsets your workplace, whether it's in support or not in support, if it upsets your workplace, you can stop it from coming into your workplace. Because you have the obligation to your citizens, your taxpayers, to run efficient government operations. And if your operations turn into a free-for-all on people's social, political racial views, that's a problem. There's another one here about that's local. I picked this one because it's right where we are almost. And I don't know if anybody's here from Kissimmee, but they had a police officer. And interestingly enough, a lot of these cases involve police officers, first responders. And sometimes they're wonderful people. They do incredible things, but they do some stupid things on social media, as you'll see. And this guy posted, "The silent majority will rise. Day one of the Revolutionary War. Hang on, it's only just begun." This was on January 6th. And then he goes on, and that first part might be okay. I don't know. But the second part definitely is going to upset the workplace. He says, for those of you who can't read it in the back, "I'm selling my white privilege card. It hasn't done a damn thing for me. No inheritance, no free college, no free food, no free housing, etc. I may even be willing to do an even trade for a race card. Those seem way more useful and way more widely accepted." What's that going to do? A couple things. You're going to have a lot of people in your workforce, white and black, upset about that. Then in your police force, which is a paramilitary organization, they all have to be acting as one. Doing this is divisive. And then what about the citizens? They're going to lose confidence in your workforce, your police force in particular. And then finally, what about the criminal defendants arrested by this officer? That's a free get out of jail card for them, right? Their defense attorney is going to say, "You did this because my client's African American." "Oh, no, I didn't." "Oh, yeah? Well, this is what you said, right?" Anybody remember the O.J. Simpson trial? Right? You remember what happened there? And that's definitely a problem for you all if you have officers or even employees that are doing this kind of stuff on social media. What about this guy? Anybody here from Miami-Dade? Okay, well, I was hoping, I still want to find out what ultimately happened to him, but this really smart guy, he puts on a Trump no more bullshit mask at the poll site on election day, which is a violation of federal law, state law, and I'm sure Miami-Dade policies. So initially, my advice would have been to fire him. Apparently, he didn't get fired. He got disciplined with a written reprimand. He didn't have a First Amendment right to do that. In fact, it was illegal, as I said, under multiple laws. That guy you'll see again right here in August of 2021, he was photographed, and this was put on social media, displaying what appeared to be a hand signal used by white nationalists. And it was posted on Twitter and subsequently removed, and then the officer was removed from his position for that. Again, he has no effectiveness to that agency or any other police agency in this country after doing something like that. And I would have advised that he be fired. I don't know what's happened. This happened in August 2021. I still don't know whether, in fact, he was fired. He probably arbitrated it. Do you know, sir?
Question is there a different, I hate to use the word standard, but if it's a clerk in my billing department that does the same things compared to a police officer?
The practical answer is yes. The legal answer is no. The practical answer is definitely yes, because the clerk is not going to interface with the public nearly as much as this gentleman would. But what does it mean to you? Or what does it say about you or your administration if you allow another employee to do it, and then this guy does it? He's going to get his job back through an arbitration, right? Because of disparate treatment. And your citizens aren't going to like it if they find out about it. So your talisman always has to be is no disparate treatment. Everybody has to be treated the same, even though they got a sad case or not, when it comes to these First Amendment issues. Now, if you're talking about, personal problems with divorce or, personal health issues, then of course you can show an apple is not an apple, it's an apples and orange comparison, right? But in this case, I would tell you, don't mess with this, because this is a problem, because then that officer gets his job back, which then divides your police department, probably leads to your police chief resigning, and the public, of course, being very concerned, and a lot of the cases not being proven if white officers are allowed to say things like that. But that's a great question, because that's the difficult thing about your job, right? You got to figure out how to apply these rules. So I would stick with, in the First Amendment arena, with making sure that there's no disparate treatment. Another question. Yeah, it's just so they can hear.
Oh, Would the result have been the same if he had not been in uniform and took the picture?
That's a great question. The answer would be yes. It'd be my opinion. I would have advised that he'd be fired. I had a case like this for an agency in the Tampa Bay area where a police officer was off duty, and he put racial things up. And you're going to see some cases today of officers in other jurisdictions that did. And I made this point with one of my clients right beforehand, is that off duty, on duty doesn't matter when it comes into your workplace later, right? It's still going to disrupt your workplace. You can't say, oh, wait a second, that happened off duty, so you can do it. And so you can't be upset in the workplace. No, they're going to be upset. It's going to affect the efficient operations of your department. And you can't have that. No matter what side of the spectrum or what the issue is, you cannot have that. You have to have efficient operations in paramilitary organizations. So this guy, I'd like to know, every time I give this speech and show him, I ask if somebody knows what happened to this guy. I might have to just ask the FOP or the PBA if anybody knows, but I hope he was fired and didn't get his job back in arbitration. How many of y'all in here have unions in your workplace? So you guys know about arbitration being arbitrary, right? One of the things that one of my clients recently learned is that you're guaranteed an arbitrator, but you're not guaranteed a good arbitrator, right? So that can be a problem, and that's why it's important, no disparate treatment. But even if you do everything right, it can still come out and be arbitrary. So here's some more examples. A federal court recently found that a Port Authority's rule against BLM masks violated their First Amendment rights. And the reason why is because they allowed other masks with other social issues on it. That's the disparate treatment issue, right? Once you open that door and think, oh, this isn't going to be bad, this isn't going to offend anybody, then somebody starts pushing that. And then the next person pushes it. The next thing you know, you have somebody with a mask that says BLM sucks. Do you think that's a problem in your workplace? How many think that's a problem in your workplace? Somebody wears that. How many would tell the employee to take it off? I would hope you would. You'd have the right to, and not worry about what that employee is going to do. So here's another police department case in Virginia where 2 police officers were terminated for participating in the January 6th riot. And they would say it's off duty. I have a right to be there. They did have a right to be there, and they had a right to peacefully protest there. But once this became a social issue, and if they were involved in going into the Capitol, then it becomes an employment issue for them. And your employees need to be aware that they can slip up thousands of miles away from where their employment is and put it at risk. There's another example here of a Houston police officer that pleaded guilty in his role, and he had resigned from the department because they had commenced an investigation into him for that. So these are the types of social issues that we face today. Now, against that backdrop, this is what the First Amendment says. I told you I was going to give you a quick primer. The important thing is here is it says Congress, which we all know is the United States Congress. But you all, as public agencies in this state, you're not only subject to the Florida Constitution, but the U.S. Constitution. And you all are the government, regardless of that same Congress, for purposes of all cases brought under the First Amendment, whether it's the U.S. Constitution or the free speech language in our own Constitution here in Florida. You cannot abridge the freedom of speech, is what we're going to talk about today. I love talking about press and assembly and religion and all that stuff as well. I love constitutional law, but this in particular is more fun than others because it's amazing how stupid people can be in what they say. And that's why you laugh. That makes me laugh. I still, after almost 35 years, I get a phone call and I'm literally just holding up and I wish somebody was in the room so I could react to it and say, I can't believe I'm hearing this. And that's why I love labor and employment law. It's not necessarily good for my clients because it's a problem for them, but it just shows you why this area of the law is so interesting. So you have to have government action. That's the example I gave of my home, my sons. There's no government action in there. My wife's the government, but it's not the real government, right? So they don't like that, but you have to have government action to infringe upon a First Amendment right. In other words, a private employer can say, like I can say to my associates, you will not put on social media that you're out partying, doing this crazy stuff, because if it just happens to be seen by a client, they're going to think, Greg, I don't want you to assign that associate to my case, because they're out doing whatever on social media. And I tell my boys that are aged 24 to 18 that the internet is forever. And I'm not a hypocrite. I tell them, look, when I was in college, I did some really stupid things, but nobody knows about it anymore. It's a vague recall, you know? Maybe there's a Polaroid somewhere under somebody's bed in a shoebox. But good luck finding that and putting that on the internet, right? So, but my boys, what they do, it's forever. And it's not just employment. And, you know, it's getting into colleges, getting into graduate school, which I have 2 in and a third wanting to go. And everything they do, they have to think about that. Your employees have to think about that. If they want to advance in your organization, I hope you all have social media policies that remind them. But then if you really have some good future leaders in your organization, pull them aside and just remind them, social media, you know, don't do anything other than vanilla stuff on social media, because that might stop you from moving up. So, and you're going to see those cases in a few minutes. But here's an example, though, of how private and government interact. If you all, as an agency, hire a security guard, and it's a private contractor, and that security guard bars somebody from wearing a shirt, in this case it was the National Park Service, and somebody had a Bush shirt on, and they said, you can't have that here on the mall, that's a violation of the First Amendment. Why? Even though it's a private company? Because they're standing in the shoes of the government. So remember that with your contractors have to be aware of that they have to abide by constitutional rights of their employees if they're doing government work for you, because they will be liable and you will be liable for that. So make sure in your contracts with your vendors that you include language indemnification and that they will follow, of course, the policies and the laws and the Constitution of the state of Florida and of the United States. All right, there's types of speech that are never protected. This is still part of the primer that you should never have to worry about. You shouldn't even have to call me. If somebody is putting up obscenity on social media and it's coming into your workplace, you don't have to call me. Fire them. If somebody is putting up child pornography, call 911. Don't call Greg Hearing, okay? If there's blackmail, any of these. Now, the ones that lawyers can spend a career on are defamation and things like that. What is defamation? You might have to call me on something like that. But, you know, anybody challenging somebody to a fight, you don't have to call me. That's not protected speech and things like that. So misconceptions are that, you know, they say, but I have a First Amendment right? And that's their first thing. And then they just don't know, though, that it doesn't protect all forms of speech and it doesn't prohibit action by private entities or individuals. And just because it's protected doesn't mean they can say whatever. And this is back to what the statute says and then what the case law says. This is the most recent leading Supreme Court case on this issue. There's actually been a couple that have cited to it that I think is very important for you all to remember. Before you pick up the phone and call your lawyer, you know, look at the speech, figure out if it would be protected or not. If it's something, you know, it's not in that category of non-protected speech. And then look at the second question is, did the employee speak as a citizen on a matter of public concern, or did they speak as an employee on a matter of public concern, or as an employee on a matter of private concern? Because this is all that's covered. So if they speak as an employee about what's happening in city government and they don't like it, they're not protected. Why? It may be a matter of public concern, but they're complaining as an employee. I don't like the way you're running the place. You know, this is awful. And they start disrupting the workplace. That's not protected. However, if they say that this city doesn't do enough to provide diversity and inclusion and things like that, that would be speaking as an employee on a matter, or as a citizen, as a matter of public concern. And it could be as an employee too. So if it's both, they might be protected. So this is where you might have to call the lawyer on this question, but it's a critical question. You'll see in some of these cases, the people thought they were protected, but they weren't, because they were not speaking as a citizen, but it's their own gripe about what's happening in the workplace. And that's not covered. There may be other statutes that cover that, but not the First Amendment. This is why it's tricky and why I could speak on this for hours, because that's when you get into the facts, when you might have to call your lawyer. And if they are, I'll just read this. The U.S. Supreme Court said, quotations, when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for the First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. That's what the last slide said, and this is actually quoting the United States Supreme Court. That's very important, because your employees are going to say, I have a First Amendment right to do that. Well, if they're pursuant to their official duties, they're speaking, then they're not covered. They have to be speaking as a citizen. The clear example would be if they go out to the steps of City Hall on their off-duty time and they got a banner, they're speaking as a citizen. If they go on their employee break on the steps of City Hall and they got a banner, they're probably speaking as an employee because you're paying them. But you might have to call your lawyer about that, and it depends on what they do. So here's a case in point I'll go over quickly. It's a recent one from the University of Florida. There were political science professors that were hired as experts in the redistricting case that many of y'all may know about. And the University of Florida had a policy that said, thou shalt not do that. And they hired a lawyer who said, you have a First Amendment right to do that. It's off duty and it's not associated with the university. And ultimately this is, I think it's over, but it was over almost immediately because Judge Walker in the Northern District of Florida issued an injunction and told the University of Florida, you can't do that. That they did have a First Amendment right to serve as expert witnesses in that case in their off-duty time. And they weren't speaking as UF professors on behalf of UF. They were speaking as political science experts. So there's these fine lines, but they're instructive. And if you're not sure, call your constitutional lawyer. So that's what that's about. I'm going to skip through that because it goes for pages. And again, I told you it's written more for lawyers, but if you want more detail about exactly what happened and what the findings were, it's in the materials. So you see it was 4 pages long. This one's a little more interesting to me. The professor's case is a little boring legally and factually because it seems like a clear-cut case. This, because I know what I know, is a clear-cut case to me, but it may not be to y'all, but it's an example of what you brought up, ma'am, about off-duty. And you all remember the Trayvon Martin trial and how, again, that was very divisive and there were people that were concerned there were going to be riots after the verdict and things like that. Well, this brilliant law enforcement officer, after the verdict came back, sent racial and vulgar text messages to fellow officers after the verdict came back. And he worked for the beach patrol in Volusia County, by the way. So it's like a lifeguard cop, I guess. I don't know. Anyway, he felt like what he had to say was important enough to ultimately lose his job over it. Because you can imagine that got bounced around, and there are a lot of people that were offended by what he said. And they occurred while he was on duty, but then later he also said things off duty, and he was equally held accountable for both. The finding by the court below was that he didn't have a First Amendment right, and it went up to our 11th Circuit Court of Appeal, which is up in Atlanta, which governs you all, and they found that he didn't have a First Amendment right to say what he said. And this is what they held. They said that Volusia County had a legitimate interest in avoiding riots and protests because of the verdict and then comments about the verdict. And their legitimate interest trumped his First Amendment rights because it would disrupt the efficient operations of the Beach Patrol Division and the police department. And ultimately, they didn't violate his right to free speech by terminating him because of that. That's the leading case for you all. Still good law, will remain good law. I don't think that's ever going to change. So that's a good, instructive, simple case to remember. Somebody on duty, off duty, saying things. Police officers, again, most likely candidates to do this for some reason. That is then going to get into your workplace and divide your workplace, disrupt the efficient operations of your PD or other operations. They can be disciplined up to firing. All right. Here's another case, though, that I want you all to consider. For those of you that are close to my age or older, and maybe a little bit younger if you were following what was going on, you all may remember when President Reagan was shot. And I remember exactly what I was doing when that happened. I was driving through an intersection in my 67 Mustang. I was living the high life. I was 18 years old, And it comes on the radio, and I about stopped in the middle of the intersection and got in an accident because of it. And I knew I was born when I was alive when JFK was assassinated, but I was just an infant. But I grew up hearing about that from my parents because they loved the man. And so, here we get the next president, assassination attempt. And it's like other things in our lives that we remember, like when the towers went down, what we were doing. I remember that. This lady, it impacted her so much that she in the workplace said, and she apparently wasn't a fan of Reagan, of our president, but this is amazing that back then in the 80s, I guess we still had some real division back then, not as bad as we have now. But she said, well, if they try again, I hope they get him. So in this case, though, this lady ultimately lost. The employer ultimately lost. The lady was found to have to be protected for what she said. And the reason is because she said this, and rather than make you read all this, and it went up on appeal twice, went to the Supreme Court, came back down. The judges kept trying to keep her fired, and the Supreme Court reversed and said, no, she had a right to say this. Why? Because she said it to one person in a conference room. And that person then started telling people, and it started to disrupt the workplace a little bit, but it was a small constable's office, and it wasn't on social media. I would tell you that today, if this happened, this person would be fired, and they would stay fired. They wouldn't have protection because of social media. It would be everywhere. Everybody would learn about it, not just internally, but externally. And, if somebody tried to assassinate Biden now and somebody said, well, I hope they get him next time, that person, that's going to be all over everything, right? That's the difference between 1981 and 2023. And so I think that's an instructive case, though, too, about what you do, because your question about the clerk, said to one person, nobody knows about it except that one person comes and complains to you. Maybe you treat that person different, but it depends on the question I would ask you if you called me is, what if it was one of your police officers? What if it was a fire lieutenant? What if it was your, fire chief? What would you do? And your answer might be different because that person's supervising people of color. And so that's a problem in so many other ways. So that's where the nuances come into play. But I like that case. I would still bring it up because it shows you that you really sometimes have to slice these issues really thin. There's another case here from the Supreme Court. It's 1983, where an assistant district attorney sent a memo around complaining about the district attorney's performance and did it internally in the office. And this is are they doing an internal gripe or a personal gripe or a public gripe case example? And it went to the Supreme Court. And this employee grievance the Supreme Court held was, with these questionnaires, didn't rise to the level of public concern that it was protected. He wasn't speaking as a citizen on a matter of public concern. He was speaking as an employee complaining about his boss. And he got fired, and he stayed fired. So that's important for people like you all to know, because you might have some people that might criticize you all from time to time. I don't know. And if it's of a personal nature, then it's not protected. Here's a case from the 11th Circuit, fast forwarding from that case about 20 years to about 20 years ago. It was a fire captain that prepared a similar type questionnaire to what the other thing was regarding the EMA and distributed it to political candidates in the county. He was placed on probation for a year and demoted to the rank of private. And as a result of that, sometimes people like to retaliate for criticism, I guess. So he sued in the Southern District in Georgia, and there's an issue of qualified immunity in the case. It's important to you all to know that you have qualified immunity. As long as you don't take action that's clearly unlawful, you're protected even if you make a mistake. That's what that issue means. But they addressed the free speech claim in the 11th Circuit, and they found that the EMA's interest in securing discipline, trust, efficiency, and mutual respect amongst its ranks. That's a much better way of saying what I've been saying so far this morning, right? That is, it's due to its status as a paramilitary organization, that is greatly outweighing his interest in making this complaint and grieving about the issues in the questionnaire. So that's, again, it's a balancing test. And if it affects your efficient operation of your county operations, then you can stop it and you'll be upheld by the courts. And I focus on a lot of 11th Circuit case law because that's where you all sit. But you're going to see a few other cases that you'll find interesting, I hope. This is another first responder case. As I said, there's a lot of these. This is a fire service. It's an assistant fire chief that criticized the city's pension concessions and pay cuts. He made the comments to the chief and various department employees, and apparently the chief didn't like that, or somebody in the city didn't like that. And lo and behold, the assistant fire chief's budget line was omitted in the next budget year. They just wrote him out of a job, and he was terminated. So he filed suit down in Miami, and the court found in favor of Pembroke Pines. He appealed, and the 11th Circuit held that the comments were made in furtherance of his job duties and thus were not protected by the First Amendment. So that's a perfect example, again, of they think they're covered, but they're not necessarily covered. He was complaining, criticizing pension concessions and pay cuts. You would think that's a public issue, right? But it was so personally interested in it and what was happening to him that it didn't rise to protection under the First Amendment. Here's another case. This is from the 10th Circuit, and it is instructive, I think, because this guy, it's weird to me, this case, this guy testifies in a child custody hearing. He's an employee of the San Miguel County Road and Bridge Department. You know, employees that are tough to sometimes recruit and retain in those types of positions. He goes to a child custody hearing involving his sister-in-law and her ex-husband, who was also an employee of the Road and Bridge Department, and he testified truthfully about his own personal knowledge about questions about the hours of operation for the Road and Bridge Department, because it was a child custody thing, and the father worked alongside him. There was an investigation into his testimony, because I assume that the father complained about his testimony, because it hurt him on the child custody thing. And the Road and Bridge Department director and the county's HR director gave the guy a written reprimand and demoted him. And so he sued them. And this worked its way through the courts, all the way up to the Court of Appeals. And after he was dismissed at the trial court level, it was dismissed by the appellate court because his speech was not regarding a matter of public concern. It was a personal matter between two people, one of his coworkers and his sister-in-law, and he went to the hearing. It disrupted the workplace because the brother or the fellow employee got crosswise with him at work because he did that. You would think, that's why I said puzzling to me at the beginning, I would think that this is something that would be protected under many other ways, even not even involving the First Amendment. But he sued only under the First Amendment, and he was fired, and he stayed fired because he disrupted the workplace on something as simple as a child custody hearing and two employees not getting along. So it shows you, again, how the misunderstanding that, I'm protected, I can say whatever I want to say in the workplace, and even to your example, maybe if it's only a couple people that are involved, I should be protected. Well, this guy was not, on something that I think is really not that controversial. Here's another one from the Fourth Circuit from just a few years ago. This is a deputy sheriff who supported the political opponent of the current sheriff. What do you think happened to that guy? I don't even have to tell you what happened to him. Well, he sued because he had the audacity to place a yard sign in his yard of the supporting the opponent to the sheriff. So he sued. He lost at the trial court, and went up to the appellate court. And the Fourth Circuit said that the individual that did this, he held a policy-making position with the county, and therefore the sheriff could refuse to keep him employed. And his First Amendment rights were not violated. So your, high-level people, your fire chiefs, your police chiefs, your assistant city managers, county managers, high-level people, if they're saying things that aren't supportive of you, and that's why I included this case, you have a right to say, you know what, your policy making, I need everybody on Team Greg Hearing rowing this way. I don't need you rowing that way. And since you're rowing that way, you just keep on rowing. You're not going to row here anymore. And that's okay for y'all to do that. It's not protected by the First Amendment. All right. This one's from the Fifth Circuit from 2019. This is a funny one to me. I included it just because it's funny. I'll admit. This is a very bright young professor, tenured associate professor at LSU that was using profanity and discussing her sex life to her students. Now, this is college level, and I'm not so naive as to think that college professors don't try to, hit it off with the young people and talk about some interesting things that I would never talk about. But this one did it to people that were studying to teach pre-K through third grade students to be teachers. So there's no legitimate basis to be talking about her sex life to these students. Some were offended and complained because maybe if they were going to teach high school kids, she could say, well, those kids are going to be having sex. You may have to give it by. I don't know. I don't know. But it's amazing to me that she was dumb enough to do that and dumb enough to sue. And it went up to the Fifth Circuit, and the Fifth Circuit said that her speech was not protected because, and I'll read it to you, the use of profanity in discussion of her sex life and of her students' sex lives was not related to the purpose of teaching future pre-K through third grade teachers, and therefore was not a matter of public concern. So, interesting, again, what people do in the workplace, right? Here's one very close to home to me, our sheriff, Chad Chronister. This is a case that's still ongoing, and I've got multiple slides on this. I'll just, in a nutshell, tell you what it's about and why it's important. These two deputies in an IA started getting questioned about, as officers are in an internal affairs investigation, about what they did and what other people did. And they were disciplined, and then they sued. They also have internal complaints, but they sued claiming a violation of the First Amendment rights and that they were whistleblowers. Now, I'm going to come back to this case in the whistleblower section. They said that what they said in the IA was a matter of public concern and therefore protected. And the court said, no, it wasn't, and you're not protected, and killed their First Amendment claim. They survived on the whistleblowing claim because they were talking about, I don't know if y'all can read it or not, among other things, that exculpatory evidence was omitted from investigation reports in internal affairs, and that members of the review board panel had a conflict of interest. And that was found by the court not to be a matter of public concern. It was a matter of their personal griping about the fact that they were subject to an IA. But it survived on the whistleblower, and we'll come back to that. Real recent case is one that also comes out of my county, Hillsborough County, Andrew Warren versus Ron DeSantis. And this, I have to disclose this as a matter of ethics. My firm handled this case. And I won't tell you which party, but if you want to know, I'll tell you because it's public record. But what happened is that Andrew Warren, in the opinion of Governor DeSantis, was not prosecuting criminals for certain crimes. And he was making statements, and it was really revolves around the Dobbs decision. After Dobbs came out, the Supreme Court decision on abortion rights, Andrew Warren said, well, I'm not going to prosecute ladies that get abortions up to a certain point in time. And Ron DeSantis had a problem with that and removed him. And so he sued, and he said, I had a free speech right to say that. And the court ultimately determined it didn't have jurisdiction over that issue, and it didn't have jurisdiction over the removal because under the Florida Constitution, the governor does have a right to remove constitutional officers. And so the court found that his suspension violated Florida Constitution, but the 11th Amendment to the federal Constitution says the federal government can't step on what the state's doing, basically. So that's an important thing for you all to know because you are the state. Even though you're local, you're the state. So federal judges may not be able to limit you in what you do, is the lesson to be learned from this. The judge said, you're wrong, you can't do this under the Constitution, but also under that same Constitution, I can't stop you from doing it. So it was interesting, and it's a Judge Walker case. So let me give you an arbitration example. It's along the lines of what I mentioned in response to you. A police officer posted racist comments and memes on his Facebook profile. And full disclosure, I handled this case for a public agency. And a citizen did an anonymous complaint. An IA was started, and the officer admitted to doing everything. He said, I did it off duty. And he posted things that were really inappropriate, that were racially charged. And he also posted a picture of his cruiser parked in front of his house with the agency name on it on his Facebook profile. So that's how the concerned citizen made the complaint. This went to an arbitration, and, arbitration is arbitrary, right? Never know what's going to happen. The union thought they were going to win that going away. But they lost. I got a good arbitrator, even though I'm not guaranteed a good arbitrator. I just guaranteed an arbitrator. But I had a good arbitrator who understood that this would and did impact the efficient operations of that PD, because black officers and other white officers were very offended by what this gentleman said. And citizens obviously were offended to the point where they complained. And this was right here within 90 miles of where we stand, where this took place. So, social media, I'm going to really run through now some social media cases in more detail with just the facts on them to save time. But this is a summary, again, of the Rankin case and Snipes case and why you have different results, I think, because of time. But I think that social media is what allows the speech to have a greater impact on public employers' ability to operate efficiently. And let me run through some cases and show you. Anybody remember this? I don't know if y'all can see that in the back. That's about 3 engines worth of firefighters up in Detroit. They get to this house and decide they cannot save it. So what do? Instead of, making sure nobody gets close to it, they all pose for a selfie in front of it. And y'all can't see it, but it's in the materials. There's about 35 individuals, including some laying on the ground like this, in front of the house on fire. You all, as administrators and leaders of your agencies, if you saw that, you'd be like, how fast can we fire these people, right? The problem is how do you replace 35 people? You can't, right? So what happened to them is they got disciplined, and believe it or not, the union didn't challenge that discipline. I guess they figured they couldn't find a bad arbitrator that's that bad that would actually rule for them, So, but what the city got out of it was a homeowner filed a lawsuit, which is not a surprise, right? So this is what social media does to people. They don't think. That's why I stress to my sons, I stress to my associates. That's why I don't do social media. Never been on Facebook, never been on Twitter. I get people that complain about that, especially in my own firm, saying that, well, that's how you have to connect to people. I do LinkedIn. And, last time I posted on LinkedIn, it's about 2 years ago. So I just don't do it. And it's mainly because I'm lazy. I don't know why people think it's so important to know for me to tell them when I'm eating for dinner and things like that. But apparently younger people think that's important. And then also their personal opinions. I don't think people care about my personal opinions. I hope they care about my legal opinions. Anyway, here's another case. This is a little bit older. It's not as old as this MySpace case. Remember MySpace? That really shows you how old that one is. But that one took a while to get to the courts. But and I never had a MySpace either. So I don't know if anybody still does, but I didn't have one of those either. But in this first one, it's a police officer case, terminated for operating a website featuring sexually explicit material. He thought it was important to have people see what he and his wife were doing in their bedroom. And then guess what? He thought when somebody was talking about it, well, I got a First Amendment right to share that stuff. Pornography is protected by the First Amendment. Well, he ran into a problem with his employer because it disrupted the workplace. And the Ninth Circuit, which is in California, which used to be thought of as one of the most liberal circuits in the country, affirmed the lower court, holding that a police officer terminated for operating a sexually explicit website did not have a viable First Amendment claim, as the defendant's interest in efficient operation of the police department outweighed the officer's interest. The one at the bottom is from the Western District of Kentucky and involved a nursing student putting on MySpace information about her patients, which is obviously a HIPAA problem now. Back then it wasn't, but it violated the school's confidentiality agreement, and she stayed fired. The case up here is the top one is important because it's, putting a political, and what the finding is putting a political campaign page reference on your personal social media is the equivalent of putting a yard sign in your front yard. It's a public statement, and it may or may not be protected. And in this case, they found that liking a political candidate's campaign page was protected speech under the First Amendment, and it was the modern day equivalent of the yard sign, and it didn't disrupt the workplace. Then this one from 2015, Third Circuit, another interesting teacher case. This teacher thought that it was appropriate to go on social media and talk about her high school students dressing like a streetwalker. And being lazy assholes and making other comments about that. Surprise, surprise, the parents had a problem with that the teacher did that. And they complained. And surprise, surprise, the school district terminated the teacher, and the teacher sued, saying that was a free speech right to do that, to comment about her students. The Eastern District of Pennsylvania granted summary judgment for the school district. She appealed, and the Third Circuit found that the school district's interest in efficiently providing a public service, educating students without parents complaining, overruled or outweighed the teacher's interest in making such speech. Here's one from the Fourth Circuit from 2017. This involved a battalion chief with the Fire and Rescue Services who was terminated for making politically motivated Facebook posts. Really shocking stuff. Again, not thinking, maybe late night drinking or something, writing, "Let's all kill someone with a liberal, and maybe we can get them outlawed too," referring to gun control politics. That led to a bunch of likes from coworkers. That's a problem too. And in that case, I talked about that arbitration case. That police officer got a lot of likes for the stuff that he did in that local agency, the one that got terminated and stayed terminated. Those people got disciplined, and they lost their arbitration as well. Because liking is equivalent of saying the same thing, right? So the plaintiff was terminated due to this disruption that caused, and he filed suit. The district court granted summary judgment for the department, tossed the case out, he appealed, and the Fourth Circuit said the plaintiff staying terminated because the department's interest in efficiently providing a public service outweighed the plaintiff's interest in making such speech, and noting that his position as a battalion chief increases the potential for disruption. Sort of what I was saying, and also about your question, the clerk versus police officer, or clerk versus chief or whatever. That's a highlight. But this is what, the 10th case I've shown you now about efficient operations? That's your talisman. What you walk out from here today is that people think they can do this in the workplace. They can't if it disrupts your efficient operations. All right? That's how you stop it. And you make it clear through your staff that your employees can't do that. Here's a Fourth Circuit case from 2016 where a police chief issued a PGO regarding social media, which prohibited the dissemination of any information that would tend to discredit or reflect unfavorably upon the department or any other City of Petersburg department or its employees. 2 officers were disciplined for posting comments critical of the department's use of rookies for instructor and special assignments. They sued under a federal statute, 42 U.S.C. Section 1983, and also the First Amendment. The district court granted motions for summary judgment and denied them in part. And the interesting thing to me about this is that the district court found that one of the officers spoke on a matter of public concern, but the other didn't. And that public concern outweighed the city's interest, while the other officer spoke to a personal matter. That highlights that one point that I already made for you. And then on appeal, the Fourth Circuit said, nope, it's both of them on public concern. But they said that the general order was too broad. It unconstitutionally restricted free speech. So review your social media policies, not only because of what's happening with board law and things like that, but if they're too broad, like that one, that's way too broad. It needs to be more tailored. Then it can cast too wide of a net. Cast so wide of a net that it becomes unconstitutional. That's why I included that case. Here's a case in the Middle District of Tennessee, which involved another police department posting comments on his Facebook account that are really some of the worst I've ever seen. There was a police shooting of Philandro Castile in Falcon Heights, Minnesota, and this guy, a police officer, commented, yeah, I would have done 5, meaning that he was shot 4 times, he would have shot him 5. And he goes on, you don't just shoot one. If I use my weapon, I shoot to kill and stop the threat. It's real, and it's what every cop is trained to do. Move to Mexico. Stop bitching about the people who protect you. This guy's unloading on the frustration that our police officers are experiencing, right? They don't feel protected, they don't feel supported, but he's doing it on social media and he's disrupting the workplace. So he was terminated, he filed a lawsuit, and he lost. And that's something I think could happen to you all tomorrow. So, again, go to your chiefs, go to your law enforcement personnel, whatever agency you're with, and tell them to remind their force that they're frustrated, they need to keep it off the social media. They need to keep it out of the workplace and not have people hear it because it will impact the operations and they could lose their job. So here's another one involving race from the Sixth Circuit. It came out of Nashville, and the result was that the Sixth Circuit found that the dispatcher's speech was not protected because it significantly impacted her ability to work with employees in the emergency communication center and detracted from the employer's mission. She just misspelled a racial slur, a version of the N-word, in responding to a comment on her Facebook page was her thing. It was my Facebook page, and I had a racial slur on there, which was misspelled, so it shouldn't count. Well, that didn't work out well for her. All right, whistleblowing, I said I'd comment about that briefly. In Florida, we have the Public Whistleblowers Act. Hopefully you all aren't too familiar with it, because if you are, that means you've probably been sued. We have a few cases with those and tried a few. But I've got a couple instructive cases. Remember the Chad Chronister Sheriff's case? That whistleblower case has worked its way through, survived multiple motions, and it's going to trial in August of 2023. So if you want the details of that, you can read about that. So that's why you need to be careful about whistleblowing and not retaliating against people that blow the whistle. We have other statutes that prohibit retaliation, and you might ask, why am I talking about this in a First Amendment thing? Because people will speak out thinking they have a First Amendment right and not really thinking that they're going to get retaliated against. But then something happens to them negatively, then they hire a lawyer that sues for retaliation, not necessarily a First Amendment claim. These things interweave together. So I've talked about public versus private. This is just a quick note. A lot of you all hire people from the private sector, and they may be well-versed enough to know that, wow, the First Amendment doesn't apply to us in the private sector, right? If they've talked to me, they definitely learn that, right? But they may come into your workplace and think, oh yeah, not really realizing the First Amendment does apply. So that's important for you all. So I said I'd cover PARA and the NORA. The Public Employee Relations Commission cases are in the materials. They involve City of Coconut Creek and Volusia County. I'm going to skip through those because they're boring. And Brevard County. PARA stuff is boring. It's very favorable for employers and for public agencies in the state, which I love because I'm a management side lawyer, unabashedly. That's what I'm paid to do. But they're kind of boring cases. The fun cases are these, which I do for private companies under the National Labor Relations Act that have unions. Like I represent several large hospital chains and several communications companies in Florida and electric companies that have private workforce. So this case, unbelievable case to me, is why I include it. And I hope you'll agree with me. If not, then you might be still a member of a union and be very, very supportive of unions, because the union saved this guy's job. What this guy did was he was up in New York City at a cocktail party, and he and a coworker were carrying around the trays, and they were talking to each other instead of going around carrying around the trays. The supervisor, Bob, comes up to Hernan and says, Hernan, and to the other guy, you all need to mingle. That's what you're paid to do. Get the hors d'oeuvres out, right? Well, Hernan goes out back on his break on the back of the restaurant, and he says, can you all hear? Okay, on the back of the restaurant, and he gets on social media with a profanity-laced rant on Facebook about Bob and Bob's mother for some reason, who wasn't at the party. So that's the teaser. So he says, Bob is such a nasty mother effer, don't know how to look at people. F his mother and his entire effing family. What a loser. If he had stopped there, he would have been fired and stayed fired. But what did he write at the end? This guy was smart. He was probably a union steward. Vote yes for the union. So that, again, is a teaser about what happens to Hernan. And poor Bob, he didn't get any relief. He got him fired, but Hernan got his job back because the union filed a charge and said that this was in violation of the employee's right to engage in protected, concerted activity. Vote yes for the union. The first part of that doesn't sound like protected, concerted activity. I don't know what Bob's mother has to do with anything about terms and conditions of employment. But the board which swings with the political winds. And over the course of my career, it's been hard to the right, it's been hard to the left. And right now it's hard to the left again. It swings. Why? Because the president appoints the majority of the board. Now, back when I was a young lawyer, that pendulum didn't swing that much. When I, for the first Bush and for Clinton and even Bush 2, it didn't swing that much. But ever since Obama got in and then Trump, it's been wild swings and now back again. And it's what's wrong, frankly, in my opinion, with our government because it's affecting business. Businesses need to have a bright line rule and understand because they'll obey it. But when it's swinging back and forth based upon the political party, it gets crazy. Well, this case occurred during the Obama administration. So they ruled that, and this is a great big thesaurus word, and I might even mess it up, that they found that Hernan's post was not so opprobrious. I can't even say that correctly, I don't think. Not so nasty, even though you used the word nasty. I thought they should have said nasty, as to lose NLRA protection. So that went up on appeal. And I'm thinking, okay, the Second Circuit Court of Appeals, not the board, they're not politicized. We're going to be saved by the court, right, on appeal, because we had some people that had an agenda. Well, we weren't saved by the court. And I don't mean we personally. I mean we as management side lawyer, because this was not my case. But the Second Circuit agreed with the ruling and said that Pier 60 violated the NLRA. And the reason why they did was that they said that the subject matter of the post included content regarding the upcoming union election. Vote yes for the union. And then this is what's amazing to me is they go on to say the election was highly contentious and the employer threatened employees who supported unionization, which makes sense then that Hernan was upset if that was what was going on. But they apparently tolerated widespread use of profanity amongst its employees, which we all know happens in the workplace all the time. But that doesn't mean that you can go on and say to your supervisor on social media and anybody that'll listen and talk about his mother. That's crossing the line. But they said that the coworkers used the Facebook to communicate with each other, and the comments did not occur in the immediate presence of customers and did not disrupt the event because he went out in the back of the restaurant and did it. But I would submit to you that, afterwards, if people that attended that found out that he did that, they would have been very upset. So you go from that case, and what lessons do you have? What do you, even though the NRA doesn't apply to you, PARA does, so what do you learn from that? So make sure your workplace doesn't allow the use of profanity, that kind of profanity on a widespread basis, because if it does, it's going to be hard for you to stop that. And people are going to be able to crassly express their opinions about unionization and employee rights. And speech posted online may receive more protection than uttered in actual presence of customers, like what your question was again about the clerk, just one-on-one maybe with a citizen. So these are the things that you want to make sure that you're even-handedly enforcing your rules and that your rules are thorough and protective. So we go from that to this, another federal case, which is amazing to me at what happens here. This involved a picket line, and some African Americans were passing the picket line going into work, and a bunch of white employees were there with their placards yelling at the scabs, right, in a union environment. How dare you go across the picket line and work, because that's their only economic weapon. Shut down the plant because by a strike, but if people cross the picket line, they can run the plant. Well, a picketing employee shouted, and this is truly offensive, but it's important for y'all to hear this about how stark this can be. Hey, did you bring enough KFC for everybody? And hey, anybody smell that? I smelled fried chicken and watermelon. And it goes on, it gets worse, and I don't even put that in there. They use the N-word, and there's another case where they use the N-word. What does the board do? After this person gets fired, because remember, they're just on strike, then they get fired for doing this. The union fights for them, and it goes to the board, and the board says that the employee had a right to do that and ordered his reinstatement. So it's really, truly remarkable what can happen. And then this went up to the 8th Circuit, not our circuit, the 8th Circuit, another part of the country, and they affirmed that ruling. And then here's one that also involved the board. And in this case, people were extending their middle fingers, which I think is just common in union disputes. That's not the problem, but we're yelling F you and the N word. And that person was terminated, and the board found that the employee's speech did not differ from the atmosphere surrounding the picketing and did not have any threats of violence, therefore it was protected by the statute. So what are you all to do with this kind of stuff? Number one, I'd say the National Labor Relations Act doesn't apply to you. So hopefully PARA, which found, I've skimmed over those cases, they weren't anything like that, and they found for the employer. So I tell you, you're in a good jurisdiction. You got a good agency in PERC right now that understands that you all have to have efficient operations. The private sector is a wild, wild west right now, and it's getting worse. Here's one where they were yelling F you, grabbing crotches, middle fingers. A person was suspended, and then the board found that that was a violation of the National Labor Relations Act, that's protected concerted activity, doing that kind of stuff. And the district court, or the District of Columbia Circuit Court, affirmed the decision, saying that although the employee's actions were totally uncalled for and very unpleasant, they could not be objectively perceived as an implied threat of the kind that would coerce or intimidate a reasonable replacement worker crossing the line. It's just amazing to me as a union lawyer that that would happen. So Trump administration, they tried to pull that back. And in this case, there was a guy at an airport that made some comments about a soccer team that had been there the year before and didn't tip him, and he remembered that. And so he started making comments on social media about this soccer team. And, you know, very innocuous compared to what I've told you about already. He was fired, and the board, now a majority Republican board, said he stayed fired, that wasn't protected. And the same thing with the General Motors case. The court departed from Pier 60 and Cooper Tire and determined that abusive conduct is not protected by the board and the National Labor Relations Act and should be differentiated by conduct that is protected. And this was profane outbursts and offensive statements of a racial and sexual nature. Person got fired and they stayed fired. See the pendulum swinging back and forth? Well, ladies and gentlemen, it's swinging back the other way. So what are you to do? You're to be glad that you're under PERC's jurisdiction, not the board. But you never know where that's going to go. Here's another case. This involved BLM and Home Depot. I'm just going to skip through that so I leave some time for questions. Any further questions from y'all? Got one? Yes. They're recording it, so I want you to say it into this if you would.
The case earlier where you talked about it was someone in fire administration passed out the survey and he lost because it was not. Yes. But could he, or his position was eliminated in the budget? Okay. Could he, if he had said that that was retaliation, do you think his case would have changed?
Great question. And what you're saying is, could he have claimed he was a whistleblower? And if the changes violated a law, rule, or regulation, yes. But I doubt so. I think there were critiques, and he was a policy-making level position. So the chief had the right to have 100% loyalty. And remember, when we talk about unions, and this applies to the First Amendment too, the higher up in an organization, they're not in unions anymore, and you can demand 100% loyalty, whether they're former union member, union sympathizer, whatever. If they're not rolling with you, you roll them out the door. Same thing with high-level people that support you all. If they don't support you, then tell them, look, it's easier to find a job while you got one, so why don't you go look for one? And here, that guy didn't get the message, apparently, and he just got wrote out of the budget. But that's a great question, because you do have to not just look at First Amendment. That's why I included the retaliation, the whistleblowing, and then, you have all the other demographics, too. You have to consider Title VII and the FCRA, the Florida Civil Rights Act, and things like that. And your HR professionals, hopefully, are going to advise you well on those issues. But a great question. Any other questions? Yes, sir.
Recently, I encountered a situation where we had a deputy chief of police wanted to run for sheriff in another county. And I wanted to take the position that he needed to decide if he wanted to resign, if he wanted to stay with us, or did he want to resign and run for sheriff, because I thought that it adversely impacted our operations. And so the city attorney advised me that because of his First Amendment rights, that I could not create that condition. And I continue to maintain that we're the employer. And, just take a look at the issues that may spill over in a political environment in an urban county and come back to our city through social media, newspaper articles, and things like that. I had to defer to the city attorney. So I was wondering what your thoughts were on that.
Great question, real life situation. So if that deputy chief is running and the officers stop respecting his authority because they think he's going to go somewhere else, that disrupts your operations. So if you've already allowed it, I would watch it very closely, because if it does start disrupting your operations, then you can take action. Because his First Amendment right is trumped by your need for efficient operations. If it starts to impact the department, your thoughts are very rational that it would impact your department, and your city attorney is being cautious, I presume, to say, let's wait and see if that actually happens or not. But if you're certain that it is, and the morale is being impacted and things like that, then you have the right to say, you got to choose. And I would give him a choice. I wouldn't just fire him. So you got to withdraw and, and stay here, or you got to make a choice to go ahead and leave. And so I'd watch that issue very closely. It's a great question. Any other questions? Yes, sir.
So you had mentioned about the water cooler talk, or the coffee pot talk from the 80s, and how that permeates now. But we still have situations where coworkers are in the common area and they're having open dialogue about an issue. Maybe it's a social issue or it's a political issue, and it creates that tension that then makes others feel uncomfortable within. There's no ill will from it. I'm a huge Trump supporter. I'm a huge Biden supporter. I'm an LGBTQ supporter, or I'm not, whatever that dialogue is, but it alienates or creates a level of discomfort and disruption with the other workers in there. Same case with how you address that.
So a real life situation. And absolutely, if that impacts the efficient operations of the department, even if just one person is offended by that and starts voicing that or taking action with regard to that, that's impacting your efficient operations, right? They're not all rowing together, rowing one way. What you should tell your people is you're entitled to your personal opinions, but keep them personal. Check them at the door. Check them at social media. Don't share them. And even if they're comfortable sharing it with another person and they share the same interests, somebody can overhear that and it can impact them. It's no different to me than sex harassment. Everybody thinks sex harassment has to me sexually harassing you. You may not have a problem with that, but people around me and you hearing me talk to you that way or acting toward you that way, that impacts their workplace environment, and it's a hostile work environment. And so it's very much akin to that. And if it becomes hostile to even one employee that then impacts the operations, you have every right to say, thou shalt not. And I have a First Amendment right. No, you don't. Not when it interrupts the operations of the department. So another great question. Any others? I appreciate y'all's attention. I hope it was at least interesting for y'all. So take care.